she had some non-sufficient funds because she wrote us a check on a closed bank account.
Well, she had told us she didn't raise any of this. She said she was going to pay it. And then some checks raised. So I adjourned it because you had presented a check. Not only did it bounce, the account it was written on was closed.
Boom. Closed account. Writing a check on a dead account isn't just a mistake. Folks, it's actually a crime in many states. Ever heard of check fraud? Yeah, this isn't starting well for Catherine.
So payment wasn't history of this case as I understand it. The title of it is Riverside Townhouses versus Catherine Yoder. Catherine Yoder is here by Zoom. The plaintiff sued for black rent in a non-payment of rent case. At the time the matter was filed in September, the arrearage was $1,186. Now we just
notice how fast that unpaid rent jumps. That's the danger with eviction cases. Every missed payment stacks, and suddenly the tenant is looking at thousands. Quick question for you. Do you think courts should give more time for tenants to catch up, or is the landlord right to push hard here?
Had a previous case, 241208 LT, dismissed in August. So by the time of September, she's now alleged to be $1,800 in arrears. So she was personally served with a complaint, and we had a hearing that was on November 15th. The amount of rent was $718, $184.47, and for a total of $902.47 due by November 25th, or the defendant was subject to eviction. As I indicated, she was personally served. She did not appear. We got an email from the defendant on December 4th. In point of fact, if plaintiff had sought the eviction before that. But anyway, it wasn't a formal pleading, it was an email. So it doesn't have anybody's heading on it. She didn't pay a filing fee. She simply said an email, didn't give service to the plaintiff, and said, I respectfully request that the default judgment entered against me be set aside. I was unable to make rent payments for the month in question because I was not working during that month due to challenges. I live in an income-based apartment and technically should not have been required to pay rent during those months. As I indicated, we just resolved another case to the same tenancy in August. I understand the importance of meeting financial obligations and other important meetings such as the scheduled court dates that I failed to attend. I did not attend to avoid my responsibilities. Fortunately, due to my mental health challenge, I was unable to respond to the lawsuit in a timely manner. I asked for the opportunity to present my case fully and discuss a fair resolution, including the possibility of payment arrangements. I am committed.
Here's where it gets interesting. The judge explains the two key things you need to undo a default judgment: a legit reason for missing court and a solid defense. Mental health struggles? That's sympathetic, but legally, it might not cut it.
Committed to resolving this matter and sincerely request the court's consideration to set aside the default judgment. So we treated it, even though it was just an email, without notice to the other party, and I set this emergency hearing. As a general rule, when a party moves to set aside a default, they have to show, they're supposed to file a meritorious an affidavit of a meritorious defense and show good cause for why they didn't show up. The defendant had shown up for hearings in August. She was personally served. She didn't show up for this one. She makes some veiled reference to the fact that she had mental health issues. I'm not sure that rises to a legitimate reason for failing to appear. And a meritorious defense, her defense, I guess, is that somehow her rent should not have been set in this amount. As I indicated, we just dismissed the other case in mid-August. She had apparently paid some rent because the claim was for more than what the judgment actually entered. So we asked the Cox Law Firm to be here. We forwarded a copy of the defendant's email to them, and Attorney Carrie Zanin is here. Ms. Zanin, what's the plaintiff's position?
Well, Judge, was going to argue the court rule. I don't believe that good cause was, well, first, I don't think we even need to get to the good cause and the meritorious defense, as this motion should have been filed within 10 days. And motion email, the judgment was signed on the 15th, 10 days would have been the 25th. She's an additional 9 days beyond that date. I don't believe she's, in compliance with the court rules as to the time frame, and I don't believe she's delineated good cause to set aside. She was personally served. She had the court date. She didn't appear, and I don't believe there's a meritorious defense either. And then, of course, September, October, November, and December are now due. So I would ask that you deny the motion.
So is it your position that once she made the August payment, that no payment was made for September, October, November, or December?
So, but what I'm showing at this point with December.
Ouch. Procedural knockout. Catherine didn't file properly, didn't serve the other side, and missed the deadlines. In court, paperwork isn't just paperwork. It's the entire game. If you miss the rules, you're already losing.
Is that she owes $923. So an extra $20, Judge, on the judgment.
All right. Now, sometimes there are a couple things. When you fail to appear in a landlord-tenant case, you have 10 days to appeal. And you didn't file anything within 10 days. You filed it on December 4th, which is 19 days after the judgment entered. Now, theoretically, on a motion to set aside default, you have 21 days to move to set the default aside. But that's in a money judgment. This was a landlord-tenant judgment for possession. So there are multiple issues. One, there's no meritorious, well, it's multiple. You didn't properly file it. It was filed more than 10 days after the appeal period. It wasn't served on the other party. We served it. You didn't file an affidavit of meritorious defense. And I'm not sure there is a meritorious defense. You simply owe the rent. Somehow it's your contention that it shouldn't have been calculated as this, but we just had another case about 3 weeks before it. And you're employed now and working somewhere in what looks like a good job. So they want to stand by the original order that's now 923. So what are you seeking at this point, Ms. Zanin? An opportunity for her to pay the rent or a writ of eviction?
I believe we are asking for a writ of eviction based on the judgment that was signed on November 15th, 2024.
All right. Ms. Yoder, what's your position?
I'm wondering, what job do you feel that I have? I've been unemployed
Well, you said
since
you were
July.
out of state as at a conference.
That is not
So
related to work, Your Honor.
Oh, okay. I thought it was.
And I've been
work.
unemployed since July 25th. And the reason why I've not, she's giving me the $528 rent fee for August is because I neglected to let her know that I quit my job at Gemstone Solid Surfacing in Elkhart, Indiana, July 25th. So she's putting that $528 for rent in August. And then the extra fees are the court fees for the missed court hearings that I missed. So how am I supposed to pay for that with no job? Plus, I've had interviews. I've applied for over 30 jobs remotely and out of in the workforce, and I've not been able to get hired. For that reason, I really don't know, other than the fact that I've been trying to do my best.
Well, I respect that, but none of that's a defense of the fact that you haven't paid your rent. Now, Ms. Kalmbach, Could you unmute? She says she quit her job. Did she ever notify management or ask for a recertification?
She did, and that's why she only owes the August rent, because she did come in and we did take her down to 0.
All right, so she owes August.
This part's huge. The judge flat out calls the bad check a misdemeanor. Imagine showing up to court asking for mercy, and the judge reminds everyone you technically committed a crime. Talk about raising the stakes.
Rent, but not, she's 0 currently.
Yes, September 1st, she went down to 0 rent.
All right, so how do we get 923?
Let me look at her ledger. She had some non-sufficient funds because she wrote us a check on a closed bank account.
Well, she had told us she didn't raise any of this. She said she was going to pay it. And then some checks bounced. And let me back up. We were here on November 4th. And she wasn't here. On November 4th, another attorney from Cox Law Firm, Jen Wilburn, was here, and Ms. Kalmbach was here. Defendant had brought in a check. She was nervous about it. She wasn't sure it would clear. The arrearage was $658, and that was through November, and it was $184.47. So it didn't include, she brought in a $658 check, but did not include legal fees. So she missed the first hearing on November 4th, but because the check had come, I waited to see if it cleared. I continued it to November 15th. Ms. Kalmbach indicated that the check had bounced and did not clear. The defendant did not appear, and I issued the default judgment. 718, 184.47, and 902.47 total. The check came back as account closed, which actually is a misdemeanor. And so the check didn't clear, the account was closed, the defendant didn't appear. She didn't file anything within 10 days, and the plaintiff still wants her to move out. All right. So,
Your Honor, could I add something else?
yes,
Back in July or August, I believe, the landlord came in to check my ceilings, and she had said that she was going to come get them fixed. And when you look at my ceilings, I can provide photo evidence as well if you need that. It's bowing down. And there's been 2 other tenants that I know of personally whose ceilings have caved in and fell.
stop. The time to raise that defense was at the time of the hearing. We were all here. Now you haven't paid the rent. You didn't file it in a timely manner. You didn't file it properly. You didn't file an affidavit of meritorious defense. And now you're raising some habitability issue that you had 2 opportunities on November 4th and November 15th to raise. So I adjourned it because you had presented a check. Not only did it bounce, the account it was written on was closed. So payment wasn't received, then you didn't appear on the 15th. Ms. Kalmbach or Ms. Cox, do you have any interest in allowing her an opportunity to pay the unpaid rent?
And there it is, eviction granted, right before Christmas. Brutal. This raises a bigger question. Should courts consider timing and compassion, or is the law no matter what? Drop your thoughts below.
Or simply ask for a writ of eviction?
I think at this time, Judge, we're asking for the writ of eviction.
I don't believe I've received it yet. Let me look.
I would rather pay the 528, meet you in the middle with that. I'm going to have to get some help, but I would be glad to do that because I don't have anywhere to move to right now.
Yeah, I do have the writ of, they don't want you to do that. I did get the writ of restitution eviction on December 9th. All right. The motion to set aside the default is denied. It's outside of the 10-day appeal period. Even if it was considered that it was filed within 28 days, there's no good cause shown for failure to appear. And there's no affidavit of meritorious defense. They don't want you as a tenant anymore, and it's going to show as an eviction on your record, which may make it very hard for you to get into any other subsidized complex. They don't, theoretically, this order will allow them to evict you tomorrow or Monday morning. But maybe they can work out some sort of accommodation or agreement. But I will sign the writ of eviction. So you're in a difficult spot. It's right before Christmas. You had two opportunities to be here. You did not appear. You presented a check for payment, which was on a closed account, so the payment wasn't made. And to further put salt in the wound, your current rent is zero. You're not going to be able to find rent for zero. So my suggestion is that you go in and meet with the manager and see what you can work out for a move out date. They don't have to serve this order for 56 days. But they can serve it immediately. That's been held since December 9th, and today is December 13th.
Can I at
The
least
date-
get my things packed up and in a U-Haul so they're not
Yes, I'm sure
putting
they'll
my
agree.
things out in the street?
It's a lot easier to have you do it than have the sheriff do it, so I'm sure they'll work with you regarding that. All right, like I said, I don't have to like it. I have to follow the law.